Good morning and welcome to Law Talks here on 4CRB. Well, for many Australians, property is their biggest asset and often something that's been built up over decades. But things can get complicated when more than one person is involved, whether it's family members, former partners, or even informal arrangements where someone has contributed financially but isn't on the title. Then there are the all too familiar disputes between tenants and landlords that many people face. And to help us unpack the ins and outs of property disputes, we're joined by commercial litigation lawyer James Griffin from Attwood Marshall Lawyers. Thanks for joining us this morning, James.
Thanks for having me.
Well, James, when two or more people own a property together, what does that mean legally?
So real property can be held in different ways, and in Queensland it can be held in two ways. They are joint tenants or tenants in common. The main distinction between these is that in a joint tenancy arrangement, all joint tenants have equal interest in the property, and there's this notion of a right of survivorship, meaning that when one owner dies, their share automatically passes to the surviving owner or owners of the property. When a property is held as tenants in common, those shares do not need to be equal, and there's no automatic right of survivorship, meaning that if that owner dies, their share can be passed down, for example, by their will or however they intend for their interest to be dealt with.
And what happens if two people share the ownership of a property, one wants to sell and the other one doesn't?
Well, look, negotiation is always the best first step. It prevents costs escalating unnecessarily. And typically, if you're in co-ownership with someone, it's assumed that you have some sort of relationship with them.
Yeah.
So if you can reach an agreement informally, that's always recommended. But in circumstances where that's not the case, there's a mechanism under Section 33 of the Property Law Act, which allows you to make an application to the court for the sale or division of that property. So what that looks like in practical terms is a trustee is appointed and they oversee the sale of the property. So the court orders that the sale has to take effect.
Okay. And can someone really be forced to sell a property even if they don't want to?
Yes, they can. It's what's called a statutory right, which means that the government have considered the interests of both owners and they've considered that the right of the party that wishes to sell is paramount to the right of the party that wishes to retain the property. The court needs to balance the interests of both parties, and in this case they've taken the view that it would be unreasonable that a party that wishes to sell needs to hold the property in perpetuity simply because the other party doesn't want for it to be sold.
And James, we often hear about situations where someone has contributed financially to a property but isn't on the title. Do they have any rights?
They certainly do, and those rights are called an equitable interest in the property. Okay. They can manifest in a few different forms, but the most common of these is what's called a constructive trust or a resulting trust, and that's where you've made contributions to either the acquisition or the maintenance and upkeep of the property, and in those circumstances you might have a right to a certain percentage of the property as well.
And I'm guessing this is where caveats come in. What's a caveat in simple terms?
In simple terms, a caveat is a legal notice on title that says that you have an interest in the property that is important to be recognised.
And how do you know if you actually have a caveatable interest in a property?
So in order to have a caveatable interest in the property, we have to first establish that you do in fact hold that interest. It can either be a genuine legal interest or some sort of equitable interest, which is what I've just discussed about, a constructive or resulting trust perhaps. It's not just an informal, I helped out arrangement. Generally, there has to be a common intention that you've made those contributions in order to receive a percentage of the property.
And are there risks to lodging a caveat if you don't really have a proper legal basis?
There are. So in Queensland, a caveat lapses after 3 months if you don't commence proceedings to establish the interest which you're claiming under the caveat. If, for example, the person who is the registered owner of the property calls your bluff and they suggest that you don't have proper legal title and they make an application to the court extinguishing the caveat and are successful, then there can be cost consequences for lodging that caveat unfairly. That usually manifests in circumstances where they're looking to sell the property and your caveat's prevented the sale.
Okay. And shifting gears slightly, what about disputes between landlords and tenants? What are some of the most common issues you're seeing at the moment?
There are two primary issues we're seeing at the moment. One is that there are rental disputes arising around the payment of rent, and I imagine that that's probably attributable to this cost of living crisis. Families are doing it tough, and that means that they can't afford things, and sometimes they miss rental payments.
Yeah.
That can be challenging because the landlord typically has a mortgage themselves. They have expenses that they have to pay. But one primary dispute is around the payment of rent. The other is where tenants aren't leaving the properties. So the rental agreements come to an end, or they've failed to make rental repayments, and the landlord has exercised a right to remove them, but the tenant's refusing to vacate. And in that circumstance, we might have to make an application to the court seeking their removal.
Okay. And if a tenancy dispute does arise, what's the best first step people should take?
So it depends upon the jurisdiction. In Queensland, you have government bodies like the Residential Tenancies Authority, and they have forms that you can issue to a tenant regarding the non-payment of rent or any other dispute that you do have with them. You issue that to them, and then if they don't comply, then you can issue what's called a notice to leave. And in that circumstance, they have to comply. If they don't comply, then you can make an application to QCAT, seeking an order that they do have to leave the property.
Yeah, okay. If listeners take one thing away from today, what's the biggest mistake people make when it comes to property arrangements?
Not putting it in writing. So under the Property Law Act, in order for a sale of a property to be valid, it needs to be in writing, and that applies to tenancies as well. While under the Residential Tenancies Act in Queensland, a tenancy agreement can be oral. In circumstances where a dispute arises, it's beneficial to have that in writing so there can be no ambiguity as to the terms that were agreed between the parties.
Yeah, well, plenty to think about there, and a really important reminder that when it comes to property, clear arrangements and good advice early can save a lot of stress down the track. Well, that's all we have time for today, James. Thank you for joining us.
Thank you very much for having me.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.